I'm going to lay out exactly what Congress changed, what it didn't, and what it means for our rights, because the Second Amendment isn't a government permission slip. With H.R. 1 now on the books, the National Firearms Act transfer and making taxes drop to $0 for silencers, SBRs, SBS, and AOWs on January 1st, 2026. Machine guns and destructive devices keep the old $200 tax. That's the win. But here's the catch: the media glosses over a zero tax doesn't automatically erase the NFA's registry or approval process. Yet, until the courts finish their work, ATF's forms and approvals still exist. So tonight, I'm going to defend the principle and navigate the reality. I'll show the black letter change, call out where the bureaucracy still digs in, walk you through the lawsuits led by states and gun rights groups, explain how Bruin and Rahimi frame the fight, and then give you the no-nonsense plan for day one. We stand for freedom, and we stay compliant while we win. Exactly what changed? Let's start with the victory that's already secured, and spell it out so nobody can spin it. H.R. 1 amends the National Firearms Act so that, beginning January 1st, 2026, the transfer and making taxes for silencers, short-barreled rifles, SBRs, short-barreled shotguns, SBS, and any other weapon AOW are set to $0. The historic $200 figure remains only for machine guns and destructive devices. In plain English, if you buy a suppressor or lawfully build an SBR after the effective date, the federal tax that used to hit your wallet is gone. That's not just a financial relief, it's a philosophical course correction. A right taxed is a right tamed. Congress just cut that leash for millions of peaceable Americans. Now, does this single change demolish the entire NFA? No. And anyone telling you otherwise is playing fast and loose with your freedom. The text of the statute changes the amount of the tax. It does not, by itself, erase the registry or the approval process. But don't miss the deeper shift Congress admitted, by action, not press conference, that citizens shouldn't pay a penalty to exercise constitutional liberty. That's momentum. That's the Overton window moving our way. And it's exactly why opponents are scrambling to preserve what they can through procedure, delay, and spin. Here's how this lands for real people. Before the law, a typical suppressor purchase required a Form 4 payment of $200 background check, approval, and then transfer. A lawful SBR build required a Form 1 with the same $200 toll. After January 1st, 2026 for silencers, SBRs, SBS, and AOWs, that payment line becomes $0. The rest of the steps, form submission, identity verification, approval, remain in place for now, because Congress changed the dollar figure, not the administrative machinery. That distinction matters. If you treat $0 tax as no process, you're volunteering for trouble. If you treat $0 tax as step one toward restoring the founder's intent, you're reading the moment correctly. A few clarifiers to keep your head clear and your record clean categories. The $0 change covers silencers, SBRs, SBS, and AOWs. It does not change the $200 amount for machine guns or destructive devices. Effective date. The switch flips on January 1st, 2026. Before that day, the old amounts apply. After that day, covered items are at $0. Purchases versus builds. Whether you're buying a suppressor via Form 4 or making an SBR via Form 1, the tax is $0 for covered categories on or after the effective date. Trusts and entities. The $0 figure applies to lawful applicants of all types. It doesn't eliminate identity checks or the need to do the paperwork correctly. What about the bigger picture? This is the government implicitly acknowledging what we've said for years. Law-abiding ownership is not a taxable sin. Cutting the tax to zero doesn't finish the job, but it strips away the most obvious price tag on a constitutional right and exposes the real debate. Whether Washington can keep a permission-based registry for common arms once the so-called tax rationale has disappeared. That debate now moves center stage in federal court, where text, history, and tradition, not bureaucratic habit, will carry the day. So, here's the bottom line for this section. On January 1st, 2026, the federal tax for silencers, SBRs, SBS, and AOWs drops to $0. The forms and approvals still exist, temporarily, but the toll booth has been lifted for a huge swath of ordinary gear. We pushed, Congress moved, and this is step one toward returning the Second Amendment to what the founders wrote. not what the bureaucracy wishes they had written. What didn't change? Here's the reality check. Delivered without surrender. A $0 tax isn't the same as no NFA. The Federal Registry NFRTR and ATF approvals tied to Form 1 and Form 4 remain in force unless and until a court or future statute says otherwise. I don't sugarcoat that. The administrative state rarely gives up power voluntarily. It must be compelled. Until that happens, the safest, smartest path for law-abiding owners is to file the paperwork correctly, keep copies, and stay squeaky clean while we advance the legal fight. And remember, blue state politicians didn't suddenly find the Constitution on their nightstand. Several states still ban or restrict suppressors and short-barreled configurations. Federal progress doesn't cancel state hostility if you travel. Check the rules and protect yourself. We are winning ground. But hostile jurisdictions will keep throwing tax in the road as long as they can. That's the playbook. Delay, confuse, deter, don't take the bait. Bottom line for now, the fee is $0 for covered items after the effective date. The forms and approvals still exist, temporarily. The lesson: be disciplined. Comply today, fight relentlessly, and don't give anyone an easy target. Our rights are not a dare, they're a guarantee. We act like citizens, not subjects. The lawsuits. When Congress yanked the tax on these items down to $0, freedom-minded attorneys general, gun rights groups, and industry plaintiffs did exactly what they should. They took the fight to court. Their core message is simple and devastating. The NFA's registration and transfer regime was historically justified as a revenue measure. If the tax is $0, the government can't keep piggybacking a sprawling registry on a power that no longer raises revenue for those items. Add Bruin to the mix, which requires the government to justify modern gun restrictions by pointing to our historical tradition, and the NFA's paperwork machine suddenly has to stand on its own legs. That's a tall order. A flagship case in Texas showcases the coalition at work, national organizations standing shoulder to shoulder with individuals and businesses, a block of 15 states signing on to defend their citizens' rights and restrain federal creep. Texas, South Carolina, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Dakota, Utah, West Virginia, and Wyoming didn't sign up to posture. They signed up to win. Their argument is clean: no tax, no tax-based registry. The Constitution lists Congress's powers. If tax revenue isn't being raised for these items, Washington can't hide a permission system behind a tax label. The plaintiffs didn't just file and hope, they moved for summary judgment, asking the courts to decide the legal question without a drawn-out trial. The government, predictably, defended the status quo and sought more time. Judges have set schedules, refused to let the issue stall, and signaled that the merits, not the bureaucracy's calendar, will decide this fight. That's exactly where we want to be in a courtroom. On the Constitution's turf, with clean facts and a clear record, what remedies are on the table, declarations and injunctions that block the federal government from enforcing registration and transfer mandates against items now taxed at $0. If a court grants that relief, even preliminarily, ordinary Americans will feel it immediately at the gun counter and in the e-forms portal. That's not a theory. That's real freedom in real time. The legal battlefield. To see how this shakes out, track the Supreme Court's compass. Bruin restored the Second Amendment to what it always was, a right whose limits must be proven by history and tradition, not manufactured by interest-balancing charts in a law review article. Under Bruin, the government bears the burden to show that a restriction is consistent with our historical understanding of the right to keep and bear arms. Apply that here. Are silencers and short-barreled rifles arms? In ordinary language and modern practice, yes, they are accessories and configurations tied to the use of arms and commonplace in lawful ownership. Does our history support a federal registry of named citizens matched to serial numbers for these items when no tax is collected? That's the cliff edge for the government. Plaintiffs say there is no historical analog for that kind of peacetime roster on common arms, especially when the enumerated Powers Foundation revenue has disappeared. They argue the NFA's lingering approval machine is a tax-era contraption stranded in a post-tax world. The government counters by pointing to Rahimi, which cautions courts not to demand perfect historical twins and suggests that objective "Nabisini shall issue" style licensing can fit within Bruin when neutral and timely. They'll argue the NFA's approvals are just that, objective screens, not ideological gatekeeping. But there's a difference between a transient license check and a permanent federal ledger that makes ordinary ownership a matter of government grace. That is a massive constitutional gap. Where do I stand rights first? If the state wants to keep a registry on common arms, it must carry the historic burden. If it can't, the registry falls, period. A zero-tax regime without a tax-anchored power doesn't magically grow a new constitutional spine. That's not how enumerated powers work, and it's not how liberty survives. Practical fallout and day one plan. Here's how I'll live my values and protect my audience the minute the calendar flips to January 1st, 2026. First, I'll file the forms for covered items exactly as the current law requires. The amount is $0 for silencers and SBRs after the effective date, but the approval step remains. Until a court says otherwise, I will use e-forms, confirm every entry, keep PDF copies, and maintain a paper trail. That's not capitulation, that's tactical discipline. You don't hand your opponents an easy prosecution while you're winning the larger war. Second, I'll monitor the Texas case and the related dockets like a hawk. Briefing deadlines, hearings, and orders are where the action is. If a judge issues an injunction that limits or halts enforcement of NFA registrations for tax-free items, you'll hear it from me with the exact language and immediate implications. If another court disagrees, I'll flag the split and tell you what it means for travel, purchases, and pending applications. Third, I'll watch for official agency guidance. When a payment field becomes zero, agencies usually publish clarifications how to complete forms, how pending applications are treated, and whether any retroactive adjustments apply. If ATF updates the playbook, I'll summarize the rules in plain English and show you how to stay squared away. The mission doesn't change. Follow the law that exists while we fight for the law that should exist. That's how we translate constitutional text into everyday liberty. One disciplined owner, one accurate application, one court order at a time. Freedom doesn't finish on a headline. It's one yard by yard. Congress cutting the NFA tax to $0 for silencers and SBR class items is the first down, not the end zone. Here's the mission going forward. Stay lawful, stay loud, and stay lethal to bad ideas. File the forms clean while they exist. Read the court orders, not the rumors. And when the bureaucracy tries to turn paperwork into power, answer with Bruin's demand for history, not hype. I'm not asking for blind optimism. I'm asking for disciplined momentum. Share this update with one person who thinks rights are rented. Support the cases that carry our argument no tax era registry. Train, vote, document everything. We're not begging for permission. We're proving a point the founders already settled. Next episode, I'll break down any new orders and the exact steps if an injunction lands. Until then, keep your powder dry, your paperwork tight, and your spine straight. We're winning because we refuse to stop.